since the 16th century. Taught me the definition of enemy. Behind enemy lines in your own home. Mentally. My soul begin in the city on the Mississippi, where a lot of niggas get left. Please get with me. Just before I hit the clutch, when a nigga shifted, use my peripheral vision, never move timid. Judge push a modern day version of crucifixion. The one who seems to bear witness be a false witness. People believe in what they see, but the news fiction. This ain't no R&B song, it's the blues, isn't it? They drop us into this society and call us menace. My brother locked down, can't communicate, ain't got no minutes. We keep the conversation brief, he say he wanna travel. Take a beautiful woman, gondolier in Venice. We the dreamers. Cash rules everything around, we the creamer. To his black coffee, donuts and 9mm. Time's been defeating us, trying to remove our feet from us. Our unity, our brothers are not keeping us. Meanwhile, Miss Lucy still reaping us, teaching us from the pulpit like a preacher does.
Watch the water hose, make them back up.
And this how we water our seeds. Teach them what they taught us, don't teach them what they need. Let's resuscitate the culture, know my niggas wanna breathe. I'm surrounded by them vultures, I ain't got nothing to feed but some breadcrumbs and seeds, my deposits to the streets. Still looking for the ownership, do away with the lease. Still putting up a fight, had a dream I was a slave. And I looked at all my people, insight is what I gave. I said and a reverend can't stop. A hollow tip from your weapon. Take a life, a mistake. You ain't learning your lesson until they put you in a hole. And the freedom's no more. Now you begging to God and you pray and you hope that it's all just mirrors with a mixture of smoke. But it ain't this real. Now you feel suicidal in the middle of the ocean and the waves are tidal. No signs of life, no signs of a lifeboat. The only thing you got is a sword, your Bible. Now the concrete has gotten indentation from your praying. I say that jail ain't good for shit, but to teach my niggas some patience. I'm here, my brother, to tell you the truth. Don't fear, my brother, your grip is too loose. Hold on, me and you about to walk up to this gate and we gon' open that bitch up. This what we gon' say.
Juggernaut, infinitesimal crushing me like an organaut, but I'm still floating, slipping through the cracks, steady on my grind, only my mind holding me back, dwelling in my temple, mental fortress of solitude, in the mellow mood, with a melancholy attitude, invade my space, shit, you like the aptitude, dimensions of compositions and broad ways and avenues, poetry paradise, complex equations, and a detailed escape plan of how to free a nation. We ain't going without a fight, we ain't going out at all, laying waste of all oppressors, free thinkers, we stand tall, piercing pituitary glands with propaganda, subliminally enslave your mind in every type of manner. They still won't stop, even when they caught on camera. Freedom is alive from Cali to Alabama, yeah.
Would I ever get free? Not watch over my back, would I ever get sleep? Paranoid the evil would get me. Use me for all my energy, drown me in 6 feet. A situation, them niggas was 10 deep. I'm rolling solo, they was in all black. I'm dressed in all white, hat on my head, look like a halo or a target. The way they look when they was marching. One of the niggas pulled something out. I kept walking cause my destination was that way. I kept praying saying, Lord, oh Lord, please don't let this be the day of gat spray. My mind was going crazy. I started thinking about my mama, daddy, and the babies. I started thinking about my brothers, cousins, aunties, uncles. I started thinking about the booty calls, my old lady. Maybe it's all gravy. Now they approaching like a block away, and the lights are shining bright at the building that I'm headed to. Maybe if they felt my humbling spirit, they think twice about doing something maybe they don't wanna do. The one in the front, he said, "Hey dog, let me holla at you." So I walk up with my guard up. "What's poppin', my man?" "Hey dog, I need a favor from you. I got this letter in my hand for somebody inside that place. I need you to give it to him face to face." "Okay, I got you." "With the man at the door tripping?" "No, the man upstairs won't let us inside the gates."
All right, peace, everybody. Um, we're gonna continue from the previous one we did a few days ago in regards to these non-judicial foreclosures and unlawful detainers. Like I said, this is something that can be different in your area, depending on what state you're in. And what I want to do is I want to start towards the end of how we ended things, and then we'll just pick up from there. So let me go ahead and share screen. Uh, okay, so let me share screen. Hold on real quick. There you go. There we go. All right, let's go here. We'll play this. Let me go ahead and mute up. Actually, have them go look at the records and see. I got to redact it, but I'm gonna show you some more documents next time and see if they're actually stating in the records that you actually sold them the house, that you actually sold it. So this deed of trust that they're talking about here, right? This one, whereas so designated in the deed of trust that was executed by this trustor. By definition, I am the donor, they are the donee. The donee of power to whom the settlor or donor of power appointment gives such power to be exercised in the case of a special power in favor of a limited class, such as members of a family, or in the case of a general power in favor of anyone, including the donee himself. So we have that information clear now. It's clear. Created a trust, power of appointment. Okay. So now, if that's the case, what are we doing here? Why is all these things going on without the authorization of the mortgagor, the trustor, the donor, the settlor, right? Lands granted from the public domain to an individual as a bounty, gift, or donation. Ah, is this what they're doing? Regularly in early Pennsylvania history, lands thus granted to soldiers of the revolution is that you donated this land or this property. They're not even saying land at this time, but this property, right? Under this power of appointment. They're not even saying land at this time, but this situation, and you tie it to a deed of trust, right? What's going on right here is what they're saying is that you donated this land or this property. They're not even saying land at this time, but this property, right? Under this power of appointment. Right? Under this power of appointment under this power of appointment for no consideration. But they're actually putting a number here because if you ask around and see if anybody got a check for the amount the thing was being sold, actually have them go look at the records and see. I got to redact it, but I'm gonna show you some more documents next time and see if they're actually stating in the records that you actually sold them the house, that you actually sold it, that you gave the trustee, the substituted trustee in here, the authorization to sell the house and not give you any money. And the sale was to pay off a debt that actually wasn't attached or in, okay, right here. So if you didn't see this one the last time, I'm showing that in these foreclosure sales under these deeds of trust, these sales aren't the sale you think it is. It is the sale of a lien. Okay, so when 100% of us believe that the property was actually being sold at these sales, it is not being sold. The lien is being sold. Okay. Um, in the notice of default. If you are considering bidding on this property, you should understand that there are risks involved in bidding at a trustee auction. You will be bidding on a lien, not you. Put that out there. This is California. They have to put this in there. It's under Rule 2924 FB8A. I want to go to the actual, there we go. So we can see it clearer. There it is right there. Okay. That's 2924 FB8A. This shows right here the language that they have to put in there. You see right here up here, this is April 1st, 2012. We all know what was going on at that time. So just know this, put my camera on. This is the law. This is not me saying this. This is the law. Anybody that refutes the law and then say you got to follow the law, need to go get their head examined. This is the law in California. And this is pursuant to non-judicial foreclosures. Okay. Now, this is the main thing that I want to get across in regards to what these processes are. Now, what I'm gonna do is I'm gonna show a few things to kind of correlate so we don't backtrack. We can just keep moving forward. You can check this other one out at your spare time. So, all right. Okay, so I showed this case right here, right? This is in the state of Minnesota. County of Scott, Township of Credit River, First National Bank of Montgomery versus Jerome Daly. Okay. This is 1968. This case right here pretty much changed the game in regards to uh, more or less how the United States government has been operating under de facto policies, codes, um, and I'm not even going to say law because it's not law, and basically have been committing constructive fraud at the highest level. Not since 1968, even before that. This one just finally got caught, right? So we're just gonna go straight to where we're at with it. Okay, so if you see right here, this is kind of just like an overview. So it says right here, it says Mr. Morgan admitted, and Mr. Morgan is uh the guy that worked for the bank. It says Mr. Morgan admitted that all of the money or credit which was used as a consideration was created with the Federal Reserve Bank of Minneapolis, another private bank. Further, that he knew of no United States statute or law that gave the plaintiff the authority to do this. Plaintiff further claimed that defendant, by using the ledger book, created credit, and by paying on the note and mortgage, waived any right to complain about the consideration, and that the defendant was he stopped from doing so. Now, let me break that down. Just that last part, where he said that the defendant, by using the ledger book, created credit, and by paying on the note and mortgage, waived any right to complain. Now, this is what I'm saying is voluntary. That's why I'm talking about donor donee, and you don't get consideration for that. The plaintiff, Mr. Morgan, the banker, these are the important things that he stated. He said the Federal Reserve Bank of Minneapolis was a private bank. It says another private bank. The bank that he's working for, which is the mortgage company that's the plaintiff here, is a private bank. Third, he states that there's no United States statutes or laws that give the bank the authority to do this. Number four, he states that the defendant, Jerome Daly, actually created the credit using the ledger book. The ledger book is the application. And by doing that, he actually transferred all rights and titles and interests over to the bank through that deed of trust. So that's what I'm saying. You got to read your contract, because what you do is, even when you make deposits in the bank, basically in their contracts, you are actually indemnifying them from all liability. The only way you can get through that is the fact that you wasn't given full disclosure. Let's continue. So right here, says jury returned a unanimous verdict for the defendant. Now, therefore, by virtue of the authority vested in pursuant to the Declaration of Independence, the Northwest Ordinance of 1787, the Constitution of the United States, and the Constitution and the laws of the state of Minnesota, hereby order, adjudged, and decreed that the plaintiff is not entitled to recover the possession of lot 19, Minnesota, according to the plat thereof. So right here, everything has been reversed or uh, stopped from the foreclosure. And here's what the judge said in 1968. He said, because of the failure of a lawful consideration, the note and mortgage are null and void. There is no lawful consideration, right? The sheriff's sale, null and void, of no effect. The plaintiff, which is the bank, has no right, title, or interest in said premise or lien. That any provision in the Minnesota Constitution and any Minnesota statute binding the jurisdiction of this court is repugnant to the Constitution of the United States and to the Bill of Rights and is null and void, and that this court has jurisdiction to render complete justice in this cause. That the defendant is awarded costs in the sum of $75 and execution is hereby issued therefore. So, any provision in the Minnesota Constitution and any Minnesota statute binding the jurisdiction of this court, right, is repugnant to the Constitution of the United States and to the Bill of Rights of the Minnesota Constitution and is null and void. So you got certain statutes and things that was implemented in these amendments, is what he's saying, that was actually in contrary or in contradiction or in contrast to the United States Constitution. So all the Constitution of the states have to be in sequence with the United States Constitution once these states came into the Union. The ones that succeeded said, no, we're not changing this, we're not changing that. We want what we want in our Constitution. But if that state is waving that banner, that red, white, and blue banner, they have to fall in line and be uniform with the United States and to the Bill of Rights. Now, what has changed? So if this was passed by Minnesota Supreme Court and they're still using the same process and they haven't seen that it has changed, then 100% of these mortgages are null and void. Based on this, this is what you call stare decisis, full faith and credit, points and authorities, precedent, case law. Now, this is the funny part, which really blows it out the water. Well, before I get to that, the judge said this. Um, the jury found that this is the judge talking. The jury found that there was no consideration and he agreed. And then he says only God can create something of value out of nothing. So the evidence, whatever was presented in this case, showed that the bank created something out of nothing. And this is what we talk about when you talk about lawful consideration. Now, if we was to know that we're gifting these things over with them without any consideration, and indemnify them from this gift, who will get involved with it? Nobody. Let's read this too. Even if defendant could be charged with waiver or estoppel as a matter of law, this is no defense to the plaintiff, right? Even if defendant could be charged with waiver or estoppel as a matter of law, this is no defense to the plaintiff. The law leaves wrongdoers where it finds them. This is American jurisprudence. Actions. No action will lie to recover on a claim based upon or in any manner depending upon a fraudulent, illegal, or immoral transaction or contract to which plaintiff was a party. This is how you get to the basis of the contract. It can't be constructed, it can't be based off fraud. It can't be illegal, and it can't really be immoral, because we're being treated as incompetent. Ignorance of the law is no excuse. You haven't read the contract. But this is the thing about the donor donee relationship. If I am fully aware of what type of contract I'm getting into, that leaves the onus on me, or the burden on me, to decide if I want to get into the agreement or not. But on top of that, it also gives me an opportunity to give a qualified counter a counterclaim, or I would say a counter offer. Because ain't no way I'm gonna sign a contract and I waive all my constitutional rights and I take on all the obligations and liability, and the bank has none. And they got the power to sell, they got the power to take it, they got the power to get interest only payments, and it's for 30 years. So they just indentured me for 30 years, right? I don't think anybody in their right mind will get into that contract. Says plaintiff's act of creating credit is not authorized by the Constitution and laws of the United States, is unconstitutional and void, and is not a lawful consideration in the eyes of the law to support anything or upon which any lawful right can be built. So remember, this is 1968. How many bailouts we've been given? How many bailouts happened since 1968 of banks? I don't know. I know two that just happened in 2000s, but we have bailouts going on. So this is a Supreme Court case. But this is still going on. And I know people will argue me up and down and call me crazy and call me stupid and say, "Oh, you'll go to jail talking that type of talk or trying to do something like that." Trying to do something like what? Do good business, solid business, honorable business, not contributing to the fraud. Because if you're going into this contract, I'm gonna tell you, you are contributing and you are a participant in the fraud. At hello. Soon as you give up that social security number, you're done. Now, if they want to get, if everything was cool, yeah, you will be a defendant. You'll be sued just like the rest of them. And guess who will come after you? Social Security Administration. If these people wasn't just so crooked, because it tells you on the Social Security card, do not give out this information for nothing. And if we ask for this Social Security card back, you better return it. That's letting you know it's not yours. People say my Social Security number. No, it's not yours. All right, let's get to the all right. So this is the interesting thing here. When the plaintiff attorney tried to appeal, this is what happened. The above judgment was entered by the court in 1968. The issue there was simple. Nothing is the law, and that's a typo. Nothing in the law gave the banks the right to create money on their books. The bank filed a notice of appeal within 10 days. The appeal statute must be strictly followed, otherwise the district court does not acquire jurisdiction upon appeal. To effect the appeal, the bank had to deposit $2 with the clerk within 10 days for payment to the justice of the peace when he made his return to the district court. Let me blow this up so you can see it. The bank deposit two $1 Federal Reserve notes. The justice refused the notes and refused to allow the appeal upon the grounds that the notes unlawful and void for any purpose. The decision is addressed to the legality of these notes in the Federal Reserve System. The cases of Edwards versus Kernzay and Craig versus Missouri set out in the decision should be studied very carefully as they bear on the inviolability of contracts. So this same court said that Federal Reserve notes were unlawful and void for any purpose. Any purpose. Remember, you go look it up. I'm gonna give you the case number after we're done. Take it back up there, but here it is. This is the you can look it up. Credit River Township case. Keep forgetting the name of the bank. Okay. So right here, with him stating that and not accepting those Federal Reserve notes, that judge set precedent on the Federal Reserve notes. Now, this is 1968. This is before Richard Nixon in 1978 totally removed the gold standard from the American way of paying debts and contracting, so on and so forth. Right. Article 1, Section 10, Clause 1, right, states that all debts must be paid in gold and silver. Okay. Doesn't say or any other type of money. So right here, with him refusing those two Federal Reserve notes, he pretty much stated that it's unlawful for any use and null and void in any term in form of payment, any form of deposit, any form of getting any expression or getting any type of right or remedy in setting up the process. He was supposed to provide two $1 silver coins or two $1 gold coins. So you see in 1968, the courts were still functioning on the gold standard. So in 1968, we could say that America was still operating constitutionally. So if they was operating constitutionally and these guys are circulating Federal Reserve notes during that same time, this is how you know where the infiltration came in of this new United States. This is what people don't understand, de jure and de facto. You got a de jure thing that was going on at that time, but once Richard Nixon took that gold standard out, the de jure became suppressed by the de facto, right? Because actually the judge is mysteriously, you know what I'm saying, uh, left. What up? What you smoke? What's going on, brother? So when we look at this right here, we're gonna set this as a foundation. Do not, while you're here, take your mind into a Federal Reserve note or a loan or credit being issued by the bank. Because this court case right here says that the way that is being done is not lawful and is not within the jurisdiction of the United States Constitution or these courts. All right. Now, now let's back this up a little bit. Let's back up what I just showed you. Right. Because I want you guys to understand the power that we already have. It hasn't went anywhere. We're just volunteering to go along with this and pretty much enslaving ourselves. Now, this is James Traficant Jr. addressing the House, right? This is a United States congressional record, March 17, 1993. Said, Mr. Speaker, we are here now in Chapter 11. Members of Congress are official trustees presiding over the greatest reorganization of any bankrupt entity in the world in world history, the U.S. government. So that makes the U.S. government a corporation. Only corporations and individuals or whatever file bankruptcy. But more or less, it says the members of Congress are official trustees. And let me show you guys something real quick. Where are we at? Let's go here. Let me show you this. I capped this. I gotta figure out how to do this. There we go.
Sure, I absolutely do. I believe transparency. You're the board of directors for this corporation called the American government, and I believe that you're entitled to those within the bounds of classification. Absolutely. So whatever.
Now, let me play that again. Now, this was 2020, what, three? I think it was like 2023. I caught this.
Sure, I absolutely do. I believe transparency. You're the board of directors for this corporation called the American government, and I believe that you're entitled to those within the bounds of classification. Absolutely. So whatever documents are out there should be turned over to the appropriate committees of jurisdiction and oversight. And whatever witnesses are needed to establish truth and transparency within the bounds of classification should absolutely happen. Absolutely. That's why I'm here.
Thank you. Chairman, I agree with General Milley, and I associate myself with his remarks.
Sure.
So now he's saying that he's the board, this is the board of, he's addressing the board of directors for this corporation that they call the American government. Now, the other guy that was talking on the other end, that's General Milley. That's a general. And it was actually talking about Afghanistan. This is 2023. So, where are we at here? Now, Let's just go down here. Not going to take too much time on this. Let's talk about this dollar. What is a dollar? Right here. This is the coinage act of 1792 and 1900s. Now, before we do that, let's go look up and see if the coinage act is still functioning. Let's go see if the coinage act is still functioning. Okay, so this is Coinage Act 1792, an act establishing a mint and regulating the coins of the United States, enacted by the Second United States Congress, signed into law by President George Washington. And I don't say that, I don't see anything over here saying that it has been repealed. Let's see. Repeal, repeal, repeal. So it says the state established the silver dollar as the unit of money in the United States, declared it to be lawful tender, and created a decimal system for U.S. currency. Let's see. Repealed, 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 repealed. Repealed. Nope. Nope. No. I don't see that. I don't see any repeal. So it states right here. That means we can go and we can validate this document. It says a dollar is a measure of weight defined by the Coinage Act of 1792 and 1900, which is still in force today. A dollar specifies a certain quantity, 24.8 grams of gold, or 371.25 grains of silver. In Black's Law Dictionary, 6th edition, dollar, the money unit employed in the United States of the value of 100 cents or of any combination of coins totally 100 cents. So this is what a dollar is. So a dollar, what we consider to be a dollar, is not a dollar. What we consider to be a dollar today is not a dollar. So how we should be stating it is note. I got one note for you. All right. Just giving you guys some backgrounds real quick. So this is an example of how these mortgage-backed securities work and how these deeds of trust and these mortgages kind of work. And I'm gonna try to make it make sense. So this is collateral used to secure bonds, right? Remember in the previous one I did when I showed that part of uh, the page 4 of the notice of default, where it said that the borrower was not contacted because the deed of the lien was not secured by a deed of trust or a mortgage that encumbered real property. I'm paraphrasing, but that's pretty much in a nutshell what it was saying. If that's the case, then you don't have something that is considered to be collateral. All right. So, in order to secure their investment offerings, some companies use portfolios of securities as collateral. A portfolio of securities is a collection of investments in the stock, bonds, treasury notes, etc., of other companies. Right? One type of investment that uses securities as collateral is a repurchase agreement. Now, this word is important. This is where your 30-year mortgage comes in. Because if you actually look at your contract, if you got a deed of trust, it says that the principal amount that you pay for, let's say it's $300,000, is not due until maturity. All you're really doing is paying interest only payments for 30 years. After that 30 years, that mortgage, that principal amount of $300,000 is due at closing. One type of is okay. So in a repurchase agreement, one party, the buyer, is lending money and receiving securities as collateral. The other party, the seller, is borrowing money and selling the securities as collateral for the loan. Now, I'm gonna try to make this make sense. You got a deed of trust. You're the bank. I'm the person coming in wanting to buy a house. I said, hey, I need a mortgage loan. They said, all right, fill out this application. So we'll fill out the application. Once I fill out the application and I sign it, and then hand it over to the bank. I hand it over to the bank. You see what I'm saying? And then the bank then deposits it and then says, okay, you now got $300,000. Go find the house. Now, mind you, the bank doesn't have the house. The bank isn't selling you anything. So just take that example and say, okay, so if we use that and we're using this this line right here, buyer and seller, the bank is buying, I'm selling. So I'm selling the securities as collateral for the loan. What is the securities? People think it's the house. No, it's not the house. Right? Let me give you an example. We're going to go to the Uniform Commercial Code. Let's go to UCC Article 5. Right? This is dealing with letters of credit. And all we're going to do is go to definitions. Okay, it's Uniform Commercial Code 5-102 definitions. All right, what is the applicant? That's me. You're the bank. I'm the applicant, right? Fill out this application. So this is the definition under Uniform Commercial Code. Commercial codes deal with contracts. Real quick, we're gonna slow walk this. Right. So the Uniform Acts that have been established as law with the goal of harmonizing the laws of sales and other commercial transactions. There we go. They're not really using the word contract. So these are commercial transactions that extend beyond, for example, goods may be manufactured. So just wanted to get on that. So now we can go over here to applicant. This definition right here, this is very important, right? Applicant means a person at whose request or for whose account a letter of credit is issued. So the term includes a person who requests an issuer to issue a letter of credit. So what's happening is that you have, in this instant, where are we at? The bank, the bank, is requesting me to issue you a letter of credit in the form of an application. But in this situation, they saying that I'm selling it to you for the $300,000. But I'm issuing the letter of credit saying issue me $300,000. So they purchased that letter of credit, or in this in this example, a security instrument deposited, connected with the Federal Reserve Bank, and then being able to say, okay, here's the $300,000. Okay. So the seller commits to buying the securities back from the temporary buyer at an agreed upon price. So that's including interest and at a specific future date. So that's your 30 years. So in 30 years, you're supposed to be buying that back. You say, okay, well, they're going to say, well, if we're going to be doing this, then, you got to pay 3.5% APR every month. So, and you say, okay, I agree to that. So then it says if the seller defaults on the agreement to buy back the securities, the buyer can sell the securities on the secondary market. Right. And then you got collateral trust bonds. You got mortgage-backed securities. See, that's what MBS is, mortgage-backed securities. We hear that a lot, but we really don't know that these mortgages are being created not just on land and with real estate per se. I'm not going to say real estate. I'm going to say land and homes. These securities are created every time you fill out an application. Every time you fill out an application, you are creating you're creating a security and extending a letter of credit that you're not even getting any benefit from. For the simple fact that they can come take the house if you stop making payments. They can sell it on the secondary market, but they do that anyway. They're already selling it on the secondary market. That's why the person, I guarantee you, there's not no person that's on this panel right now that's going to listen to this later can say that they are paying the initial bank that they started this contract with. I put $1 million on it I ain't got. Now let's go see what a letter of credit is. So a letter of credit means a definite undertaking that satisfies the requirements of Section 5104 by an issuer to a beneficiary at the request or for the account of an applicant. So by an issuer to a beneficiary. Now, this is the reason why when you look at your deed of trust, the bank is always going to be the beneficiary. But I've talked to plenty of bank VPs, and they said that you can add anybody as the beneficiary. The bank is going to be there for the initial transaction. You can always amend that deed of trust, substitute the trustee out, put your own trustee in, and then add your children, your wife, your husband, whoever's in control how the situation go as the beneficiaries of that deed of trust, because it is a security instrument. All right. So No, no. All right. Wait a minute. All right. Okay, so here's what we're dealing with right here. See, anytime people missing this right here, you get sovereign citizen. Well, let me bring this back up. What I brought up the other time. Let's go to where was that thing at? Well, you know what? I'll do it even better. I'll do it even better. Executive order. But before we get there, keep in mind we just saw that daily case. We just looked at it. We just saw the daily case, right? This is Franklin Roosevelt forbidding the hoarding of gold coin, gold bullion, and gold certificates. Now, this is how you got reclassification on two different levels. Yeah, we got the reclassification of the black Negro colored from the original Aboriginal American Indians, right? And on another time, I'm gonna show you how it was done and how it related, and it's hidden in plain sight if you actually see who was actually involved with some of these things. Now it says right here, and I'm just gonna get down to it. He said, I, Franklin D. Roosevelt, President of the United States of America, do declare that said national emergency still continues to exist pursuant to said section, do hereby prohibit the hoarding of gold coin, gold bullion, and gold certificates within the continental United States by individuals, partnerships, associations, and corporations. So if individuals, partnerships, associations, and corporations are forbidden to hoard gold coin, gold bullion, and gold certificates, does this apply to people? All right. Let's go in law. Okay. There we go. Now this is uniform commercial. This is United States Code. Person, human being, child, and individual as including born alive infant. Shall include every infant member of the species Homo sapiens who is born alive at any stage of development. Okay, that's one definition. Individual, as a noun, this denotes a single person as distinguished from a group or class, and also very commonly a private or natural person as distinguished from partnership, corporation, or association. But it is said that this restrictive signification is not necessarily inherent in the word, and that it may, in proper cases, include artificial persons. Case law, right here. Now, these are artificial persons. So, if we have something right here that's saying within the continental United States by individuals, partnerships, so we're talking artificial persons. These are artificial entities. If you know about the 1040 tax return, right? It's an individual income tax return. When you fill out a 1040, just being brief, when you fill out a 1040, you automatically put into small business self-employed. That name is actually considered to be a small business self-employed entity. Okay. I want to look this up real quick. What is the continental United States? Um, some sources incredibly mix up which because simply hmm. All right. That's not giving me anything. So now we got a clear idea of what we got going on with the executive order. The executive order never dealt with the people, but for some reason, the people during that time ended up being convinced that they were a part of that. This is where these things get tricky because these publicly offered uh these publicly offered debt instruments are all being put out in plain sight so people can see. But it doesn't pertain to you. It doesn't pertain to us. Let me see here. Let's go back over here to this. So now that we know that the executive order that Roosevelt put in was dealing with the suspension of the gold clause in regards to, hoarding or it being used. So it was discouraging people from actually using coin and started putting these notes or pretty much what they call these receipts. Because really how they started, these receipts were the actual proof that you had gold in your bank. So they started exchanging those papers, and eventually those papers end up being utilized as money. But you can always redeem them though. See, with the Federal Reserve notes, they cannot be redeemed because it'll say on the receipt, redeemable in X amount of dollars in gold or X amount of dollars in silver. So if we look at House Joint Resolution 192, Public Law 73, as used in this resolution, the term obligations, any obligation, including every obligation of and to the United States, accepting currency payable in money of the United States. And the term coin or currency means coin or currency of the United States, including Federal Reserve notes and circulating notes of Federal Reserve banks and national banking associations. Okay. 18 U.S.C. subsection 8. Obligation or other security of the United States defined. The term obligation or other security of the United States includes all bonds, certificates of indebtedness, national bank currency, Federal Reserve notes, Federal Reserve bank notes, coupons, notes, notes, gold certificates, silver certificates, fractional notes, CDs, checks, drafts, money drawn by or upon authorized officers of the United States, stamps and other representatives of value of whatever denomination issued under any act of Congress and canceled United States stamps. Okay. Now this is everything that you need to know in regards to how to function in regards to the debt and dealing with these banks and some of this extended credit. So you got 15 USC 1691, 1602, 1692. Okay. I'm not going to go into these. I just want to show you some of these things to look into, how they apply. Oh, no, no, no. Now let's see, all these things right here is things that I utilize, right? They come my way, I'm utilizing these. Now, take a look at this. Okay, so this is in Texas. Here's the case number. This is an adversary proceeding. This is in bankruptcy. So you can see this is bankruptcy. Anytime you see adversary proceeding, that's bankruptcy case. So this is plaintiff's memorandum of law on credit loans and void contracts. It says right here, history of money and banking, the Goldsmiths. In his book, Money and Banking, 8th edition, 1984, Professor David Emerson writes on pages 56 to 63. The first bankers in the modern sense were the goldsmiths, who frequently accepted bullion and coins in storage. One result was that the goldsmith temporarily could lend part of the gold left with them. These loans of their customers' gold were soon replaced by a revolutionary technique. When people bought in gold, the goldsmith gave them notes promising to pay that amount of gold on demand. Okay. The notes first made payable to the order of the individual were later changed to bearer obligations. In the previous form, a note payable to the order of Perry Reeves will be paid to no one else unless Reeves had first endorsed the note. Now, right here, the evolution of the credit system. Later, the goldsmiths learned a more efficient way to put their credit money into circulation. They lent by issuing additional notes rather than by paying out in gold in exchange for the interest-bearing note received from their customer. Now, see, this is the point. This is the point. As I mentioned, and if you saw the definition in 5 USC 102, is that the applicant is one that's issuing letters of credit. So this is where the bank barons came in and they got fouled, because when we was allowing these banks to open it up, and pretty much they were just holding tanks. But it was under the assumption that they can actually utilize the reserves or what they had as collateral to create more money. So what they was doing is they was creating credit that really was based off of nothing, because it wasn't their goal, but they were utilizing it as collateral. This is why in the 1920s, that's why the banks all got shut down, and people couldn't find their gold. It disappeared. Now, modern money mechanics, right? This is with the Federal Reserve Bank of Chicago, right? They say it started with the goldsmiths. At one time, bankers were merely middlemen, and that's all banks are. They're nothing but brokers and barter exchange middlemen, right? So now let's get to these documents. Let's get to these documents. I want to show you guys again. We're gonna show again. And what I can do, which is better, is instead of reinventing the wheel, I could just bring up the video. As you can see, this is California Civil Code 2924F. We go to B. So I'm gonna pull up some of this stuff right here and show you who that handsome man there about these foreclosures. And I'm gonna show you the documents, right? I'm gonna show you the documents. I'm pulling it up right now and then I'll share the screen. So if you see right here, right, this is a notice of default. This is a notice of default. And this is in California. If you see right here, this is the declaration of mortgage servicer pursuant to Civil Code 2923.55C. See, I took out all that information right there, but it has 4 boxes you can check, right? There are 4 boxes you can check. Let's go through each of them. It says the undersigned declares that, which is this one, the mortgage servicer has contacted the borrower pursuant to California Civil Code subsection 2923.55B2 to assess the borrower's financial situation and explore options for the borrower to avoid foreclosure. 30 days or more have passed since the contact was made. So that didn't happen. And here's the key thing here. Mortgage servicer. Doesn't say mortgage lender. Doesn't say mortgage creditor. It says mortgage servicer. So they're servicing the mortgage. Right? 2, the mortgage servicers has exercised due diligence. No of reference loan is not secured by a first lien mortgage. Now this one was checked. There's no contact was made with the borrower pursuant to California Civil Code 2923.55 because the above reference loan is not secured by a first lien mortgage or deed of trust that secures a loan or that encumbers real property described in California Civil Code 2924.15. Now we're going to look up these codes here. So what they said is they did make contact with the alleged borrower for these specific reasons: that the loan is not secured by a lien, first lien mortgage. So that means no mortgage on it. So how are they a mortgage servicer or deed of trust, right? That you need to have, right? When you buy property, they actually, in the double close or simultaneous close process, they actually assign and transfer the instrument, the note, over to a real estate investment trust or an investment company that takes it over. And then they use that deed of trust as it is because it's a security instrument, right? But it says right here, first lien or deed of trust that secures a loan, right? So It shows right here that the deed of trust secures a loan, and also the above referenced loan is now. I did a shitty job of explaining this. Let me clear it up a little bit. In the non-judicial foreclosure process in California and in any other state that has a non-judicial foreclosure process, what you have is a process you have to go through. You have a corporate assignment of deed of trust, and I haven't showed that because that's too complicated. But the notice of default, a substitution of trustee, and a notice of trustee sale, right? But these codes specifically state that pursuant to these codes, the borrower was not contacted because these instruments are not attached to real property. But in these non-judicial foreclosure processes, they're still going through it as if it is attached to property. This is what's going on in these non-judicial foreclosure states. They're committing fraud at the highest level. It's theft. And they're utilizing instruments and they're utilizing these agencies in order to execute this, because this is recorded in the county. So when you look up, let's get to this part right here. Let's go. So you have this right now. Keep this in mind. Keeping all the other things in mind. Keeping all these things you're keeping in mind. The daily case, everything that I just showed, the Coinage Act, the ruling, the Federal Reserve notes, the denial of the appeal based on Federal Reserve notes, the reversal of the sales and the instruments being null and void without consideration. And this is 1968, and this is 2019. When this was filed in 2019. So let me see. Let's get to the code. Man, it's taking too damn long. Let's go back here. Let's go back here. Let's go. California Civil Code 2923.55. What you doing, man? All right. So in 2923.55, it says right here, mortgage servicer, mortgagee, trustee, beneficiary, or authorized agent shall not record a notice of default pursuant to section 2924 to all of the following. The mortgage servicer has satisfied the requirements. 30 days after initial contact, the mortgage servicer companies complies with the section that the borrower has provided a complete application. The mortgage servicer shall send the following information in writing to the borrower. A statement that the borrower is a service member, blah, 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 right? A statement that the borrower may request the following: a copy of the borrower's promissory note, a copy of the borrower's deed of trust or mortgage, a copy of any assignment if applicable. None of these things are being done. So if none of these things are being done, right? As it's stating right here, none of these things are being done. What are we doing? What are we doing? So now we go to California Civil Code 2924.15. Right? It talks about first lien mortgages or deeds of trust secured by owner occupied residential real property. It says this shall only apply to a first lien mortgage or deed of trust that meets either of the following conditions. First lien mortgage or deed of trust is secured by owner occupied residential real property containing no more than 4 dwelling units. For purpose of this, owner occupied means that the property is the principal residence of the borrower and is security for a loan made for personal, family, or household purposes. So, right, pursuant to 2924.15, the alleged borrower was not contacted. Now, when you get to a notice of trustee sale, right, which comes next, you got the notice of trustee sale after the notice of default, if the people aren't paying. But here's the thing: these things are invalid from the gate. They're invalid from the gate because none of these things have yet been determined or been shown. But this is where the non-judicial foreclosure process has been instrumental in putting a lot of people in problems. And they really got busy during the shutdowns. I mean, I would say once the moratorium was up, I would say the next month over close to 4,000 people were foreclosed on. And that was in 1 month. January, February, I would say. So let's go here. So the notice of trustee sale, let's go to California 24F. Right. So as you see right here, this is dealing with property, means real property or leasehold estate therein in calendar week. Right. So this is dealing with property. So you got A, you got B, and then we're gonna go all the way down to 8. So right here it says on or after 2012, the deed of trust or mortgage containing a power of sale and secured by real property containing from 1 to 4 single family residences. The notice of sale shall be contained substantially the following language, in addition to the language required pursuant to paragraphs 1 to 7. So, if, remember, it's stated in the notice of default on the declaration page, box 4, it said that no deed of trust or mortgage is secured by real property. This says on if the deed of trust or mortgage, if the deed of trust or mortgage containing a power of sale is secured by real property. The only way you could do a notice of trustee sale or publish it, or even try to, well, let me just say, publish it and record it in the county, it has to be secured by real property. Let's just go back. Says right there. The above referenced loan is not secured by a first lien mortgage or deed of trust that secures a loan or that encumbers real property. So it says if all those things are done, you still have to put in this language coming up. The notice of sale, the notice of sale shall contain substantially the following language in addition to the language required pursuant to paragraphs 1 to 7. And it's got to say this, and it does say it on second page. Anybody that sees this notice of trustee sale in the county recorder or is getting an alert of it, they're going to see this on the second page. If you are considering bidding on this property lien, you should understand that there are risks involved in bidding at a trustee auction. You will be bidding on a lien, not on the property itself. Plain language. You're bidding on a lien. And if you place the highest bid, it does not automatically entitle you to free and clear ownership of the property. Now, this is where the twist of the words come in, because I don't even know why this line is even in there. It should say placing the highest bid at the trustee auction does not entitle you to free and clear ownership of the property. Not automatically. Third of all, you looking at it is the debt even valid? As I mentioned before, the initial lender, like I said, 100% of everybody that listens to this now or listen to this later that is not paying the same bank that actually started the loan transaction, or we will call even the commercial transaction, or the retail installment credit application. Zero. Nobody. And I told you I got $1 million that I don't have. Prove it. So if you do not have anything secured by real property, you shouldn't even be filing the notice of trustee sale. If you do, you still at the auction are only buying a lien. But if the bank is supposed to be so lawful and so lending and they have the money and they're doing this and doing that and so on and so forth, which everybody likes to argue, why can't they enforce this lien? Why are they selling it? Let me ask this question again. Why are they selling the lien? Why aren't they enforcing it? Or I should say, why can't they enforce it? They can't enforce it. That's why they're selling it. Because then here comes the party. Because it's only a lien being bought. And this is non-judicial foreclosure states. It's only liens being bought. I don't know how it is in other states in regards to how the banks operate. But 9 times out of 10, no, 10 times out of 10, unless maybe you got a loan at a credit union. So now what happens at these after the foreclosure sale, right? What happens is that they then try to ask try to ask you to leave, right? But it's voluntary. So what they end up doing is they conjure up these documents, right, in the form of like a landlord tenant agreement. So now instead of homeowner, they start calling you an occupant. They say, "Oh, you are sitting here and you got to pay this, or you're going to have to be evicted." So they're actually starting an administrative process against you as a landlord tenant. Then what they do is they actually go to court. They actually go to court, and then I'm just stopping my screen because I'm gonna pull something up real quick. It actually they actually go to court Go to a landlord tenant court, and then what they do is they actually present a complaint. They actually present a complaint for eviction. And I mean, this is how this process is going. I'm thinking now. Should I even present this? Hold on, man. Hold on, man. Let's take a commercial break. Let me get some of this stuff together because I'm gonna have to redact this. Let's go to the yeah, yeah. Let me do that. We're gonna take a quick commercial break. What time is it? 1:42? All right, we're cool. Uh,
Sunday Showcase, made possible by a public service grant from the National Endowment for the Arts and Bristol-Myers Company in association with its divisions.
All right, y'all. Yeah, so basically I had to redact all this stuff out. I'm not about to do all that. But appreciate the patience. Um what I'm doing is show you how it looks, you know, and what they're bringing up. And based on what we just showed, you will see that the whole unlawful detainer complaint is fraudulent. It's a faulty complaint. It should have been thrown out instantly. Because if you understand the law and what we read in regards to that notice of default and the rules on the notice of trustee sale, that the sale of the property wasn't a sale of the property. It was not a sale of the property. Okay. Please, all these names redacted. All right. All right. So let me share this screen real quick. We're gonna go over this and then we're gonna call it. Appreciate y'all chilling with me. Now, remember, we looked at the we looked at the notice of default in the previous thing, and we can let's go take a quick look back since I took too much time. Right, we look right up here. Uh, okay. So in order to file a notice of trustee sale under 8A of 2924F, B8A, the property, the deed of trust or mortgage containing the power of a sale had to be secured by real property. Let's get that straight. And as we saw in the video, as we saw in the video that I did previously, that no contact was made because the above referenced loan was not secured by a first lien mortgage or deed of trust. So let's keep those two together. All right, let's keep those two together so we don't get far off. Let me show you this real quick. Right, the initial, right, the initial. I should leave her name up there, damn crook. The initial complaint says complaint for unlawful detainer following foreclosure sale action based on Code of Civil Procedure Section 1161A. That title right there pretty much is willful and intentional fraud upon the court. Based on what I just showed you, what that notice default says. The notice default says that is not secured by a first lien mortgage, right? The lien is not secured by a first lien mortgage or a mortgage or a deed of trust. I'm sorry. So if that's the case, the heading in itself needs to be thrown out. But the clerk didn't do that. The clerk can actually throw it out even before it gets to it. Now let's look up real quick what is 1161A. All right. So what 1161A states is um, Okay, so 1161A states that um, manufactured home, mobile home, what does it say? 1161A. What am I looking at here? Okay. So if, so if this is saying 1161A, it's using this section, manufactured home, mobile home, floating home. What is that talking about? What is that talking about? This is 1161A, right? This is 1161A. This is 1161A. So this is coming pursuant to 1161A. So 1161A is dealing with manufactured home, mobile home, floating home. Now, this is why I say when I pulled up the portion, right? When I pulled up this portion of this, I want to show you real quick in this video what I showed. I'm gonna pull it up. I want to show you the I want to show you why you still that you own the land. There you go. Now I showed right here that this is a title insurance policy. Right here it states the estate or interest in the land hereinafter described or referred to covered by this report is a fee. Right? I went in and I showed by definition in the Black's Law Dictionary what this fee means. It means fee simple. And I'll show you that in a minute. But it says right here, title to said estate or interest at the date hereof is vested in that name. It does not mention property not one time. It says this the estate or interest in the land. Now, one I just found something because I said, oh, I never actually studied this code like I did because I was trying to find it didn't make sense. What is a floating home? Now, I don't know if anybody knows, but every house can be picked up and moved. That's the way these houses have been set up. They have these things up underneath it where it can be picked up and moved. The land is immovable. So regardless of what's happening, and this is where eminent domain comes in, because if the interest is just in the movable object, which is the floating home or the house, or the mobile home, or the manufactured home, because a house can fall under all three of these sections. Then what happens is that they need to pick up the house and take it because the land has not changed. The land possession has not changed. Who's the owner with interest in the land? Now I know I just veered off a little bit, but I need to veer off real quick. I need to veer off real quick. I need to veer off real quick. Get out the way. Okay, you guys see that? It says estate and fee simple, right? I just read that. I just showed you what it said in here. We're gonna walk this down. It says the estate or interest in the land described or referred to covered by this report is a fee. So this is an estate in fee simple. So now what we're going to do is we're going to go back here. Let's go to Black's Law Dictionary. Estate in fee simple says see fee simple. All right, here we go. Fee, a charge fixed by law. Okay, boom. Okay, so this is a fee dealing with estates, right? So this is a fee dealing with estates. Ordinarily, word fee or fee simple, same thing, is applied to an estate in land. The term is applicable to any kind of hereditament, corporeal or incorporeal, and is all the property and thing referred to or largest estate therein which person may have. So now let's go to fee simple. So, okay, so let's do this one as well because it's all the same. Fee simple. It says American law, an estate of inheritance without condition belonging to the owner, inalienable by him or transmissible to his heirs absolutely and simply, and is an absolute estate in perpetuity. All right. So remember, don't forget about fee simple, absolute. A fee simple absolute is an estate limited absolutely to a man and his heirs. Conditional. At the common law, estate and fee simple conditional was a fee limited or restrained to some particular heirs. American law. An absolute or fee simple estate is one in which the owner is entitled to the entire property with unconditional power of disposition during his life and descending to his heirs and legal representatives upon his death intestate. So what the hell is this? How are you saying that you were foreclosed, you come into an unlawful detainer court to get an eviction based on a sale that didn't of property, well, based on the sale of a lien that did not go to property. And you're stating that you're evicting me from somewhere on something that I have an estate interest in. So let's see what this fraud is all about. So right here, you see JP Morgan, it's the signs and or successors. And I'm gonna get back to that real quick. This is where I'm gonna show you these things are real estate investment transactions. Is entitled to possession and is the owner of record of a parcel of real property located at boom. The subject property is located within the above referenced judicial district and county. Now, we already know that first paragraph is a lie. That is absolute perjury, period. So the perjury and the lies and the fraud upon the court is going to continue. Then it says that JP Morgan and Chase, its assigns and or successors, is an entity lawfully conducting business in California. Now, anybody on their own time, I don't want to jump around again. I can actually pull up the records in California that says that JP Morgan Chase Bank is a foreign corporation. Because if you're in another state and your principal location is in another state and you do business in another state, that other state is still considered to be foreign. People think foreign is some across the seas or in another country. No, all these states are countries. And if you're domestically located in California and you set up business in another state, you're considered to be a foreign state. Now, let's see the other part of the fraud. Defendant at all times herein mentioned resided in the boom. And seeing they're using this word resided, that's another conversation. Defendants and each of them are currently in possession of and occupying the subject property. See, all this is constructively fraudulent because they're saying occupy. They're in possession and occupying. See, they're supposed to be saying peaceful possession. You can say occupying if you want, but you're not stating that they are the owners. As it shows right here. And this is a preliminary title report. Now, defendants is the former trustor or a holdover occupant of the former trustor. Right. What does that mean? The true names and capacity were individuals, corporate, associate, or otherwise of the defendants named herein as those 1 through 10 inclusive, and each of them are unknown to plaintiff, who therefore sues said defendant by their fictitious names under Code of Civil Procedure 474. The true names and capacities were the individual corporate. See, all this is legalese conversations that has nothing to do with any facts whatsoever. There has not been one fact made. Plaintiff is the owner of and entitled to immediate possession of the subject property. Now, what did I show you in the notice of default? It's not connected to real property. Another perjurous statement. Plaintiff owns the subject property by virtue of a foreclosure sale duly held pursuant to the power under the deed of trust executed by defendants or their predecessors. We saw 2924 FB 8A of the California Civil Code states that you're not buying a property, you're only buying a lien at these foreclosure sales in the notice to potential bidders implemented in the notice of trustee sale. Number 8, defendants or their predecessors defaulted under the terms of the deed of trust, which secured property, the subject of this litigation. Notice of default and breach of conditions of the deed of trust and election to sell of the property to satisfy the obligation thereby secured was recorded. Now, there is that document that I showed you that was a notice of default where you seen the declaration does not state this. That's not the title. That's another lie. After failure of defendants or their predecessors to cure said default, a trustee sale of the property was duly noticed as required. Another lie. At the time and place notice for trustee sale, the subject property was sold to plaintiff in compliance with California Civil Code Section 2924. ETSEQ means insequential, meaning the whole 2924 code. And that's a lie. The trustee's deed upon sale was thereafter recorded. Now that was true, thereby duly perfecting plaintiff's title to the subject property. Now that part is a lie. So this is true in part. They did file it, but it did not perfect anything because it said you're only buying a lien. So basically what they did file was a lien. But what happens is that they actually take that trustee's deed, actually a real deed, a grant deed from the owner, which is still the true owner of the land, and under the grant deed as actually a sale to them, and then they change title. You see, but in this situation, this was considered a bank-owned property, but it really wasn't even a bank-owned property because none of that was true. Bank wasn't there, no representatives from the bank was there, and nobody made a purchase. Because as I was told, everybody was ran off, but nobody there. So it's something that they call a revert back to the beneficiary. Remember I spoke about beneficiaries prior to that. So when you talk about beneficiaries, that is when you're dealing with that the part of the repurchase agreements, and the part of the beneficiary being gifted something, right? Without consideration. Now it says number 12. Defendants were served with a written notice requiring defendants and all persons in possession of the subject property quit and deliver up possession of the property. Now, from what I was told, that is a lie as well. A true and correct copy of said notice for possession is attached here as Exhibit 2. Now, how you got notice of possession of something when you didn't buy it? You only buy the lien. And how you buying something? How was the notice of trustee sale put in place when the notice of default said that the lien wasn't attached to real property? So I'm giving you guys language. This is how you communicate when you counter. These are the questions. You're asking questions, not making statements. Now, it said true and correct copy of the proof of service of notice for possession is attached here to as Exhibit 3. I got the exhibits up in a minute. So we got 2 and 3. What about 1? At any point in time, so far, have we heard anything about the exhibit of something that is supposed to be in place, the main component of an eviction? What needs to be in place? Correct. A lease agreement, a California lease agreement. Let's see, 13, defendant have failed and refused to deliver up possession of the subject property after expiration of the notice as required by California Code of Civil Procedure 1161 AB3. Another lie. Defendant continues in possession of subject property without plaintiff's permission or consent. Look at it. Look at it. It's continuing. This is psychopathic here. These are people with no blood flowing through their veins. These aren't people. These are predators. Have you ever heard of a predatory loan? These guys are predators. And these attorneys that actually are in California that are pushing this are actually the ones submitting these things. Let's continue. Let's see here. The reasonable value of the use and occupancy of the subject property is equal to an account according to proof at trial. And damage to the plaintiff caused by defendant's unlawful detention. Look at that word, unlawful detention. Now you're using these words. These are like criminal type words. You can actually utilize these in a criminal aspect. So you're actually coming to the court, a landlord-tenant court, and you're telling the court that the owner of the property that you didn't buy the property from, that based on a foreclosure that wasn't attached to real property, a lien that wasn't attached to real property, and a sale where it says that you're not buying the property, you're only buying a lien. You're coming to the court and saying that these people are criminal. And they're owners with interest in the land, with an estate in the land, meaning it goes to the heirs in fee simple. That's absolute. Don't worry about it. I do this for a living. That's why I can come off the top of my head like I do. I do this for a living. Don't trip. But it's still common sense though. It's just common sense. So wherefore, oh well, there she go. That's the fraud right there. And there's plenty of them out there. Plenty of them. Wherefore, plaintiff prays judgment against defendants and each of them for restitution of the subject property, damages, cost area, and further relief as is proper. Now let's look at the exhibits. Now this is the notice of possession. Now let's see if these match. It says a true and correct copy of said notice of possession is attached here as Exhibit 2. This is Exhibit 1. Notice of possession. Another lie. So they're using this as their administrative prejudicial procedures of eviction. And you see right here, it says all persons, excuse me, all persons in possession of the premises. What is Exhibit 2? Oh, this is the trustee's deed upon sale. Now, when I went through it, this Exhibit 2 in the court case docket says that this is the rental agreement. And at this point in time, they're stating that the the people that own the house, own the land, actually granted it to them. This is what this company, this is Quality Loan Service Corporation. I found out, well, we found out in working with other people that this company is actually ran by the actual attorney firm that you just saw. They're not all of them, but most of them, actual firm own the firm partners, the people at the top are actually the directors of this company that actually was supposed to have executed all these fraudulent documents and filed that unlawful detainer. So they saying that as trustee, whereas so designated in the deed of trust, here under more particularly described or as duly appointed trustee. These are statements being made and being published, and they're not true. They're saying that they hereby grant and convey as trustee of the deed of trust. Now, I just showed you all the things prior, so let's move forward. Now, this is actually 2 pages. That if I showed you the actual trustee's deed upon sale, it's 3 pages. They actually took 1 page out, and that was the notarized page. Let's see what Exhibit 3 is. Oops. The 3rd page. This is the 3rd page of the trustee's deed upon sale. See, it's tedious, but once you know what you're looking for, then you don't have to do all the other things. But here's the most important thing, what it says. Quality may be considered a debt collector attempting to collect a debt, and any information obtained will be used for that purpose. So quality loan is actually, this is a debt collection instrument. Why would they put quality as it may be considered a debt collector? Why are they attempting to collect a debt when this is already a trustee's deed upon sale and is granted and conveyed? It's just something to think about. I'm trying to put the pieces. This is how I'm letting you know how my mind works. This is how it works. Why are you putting a debt collection notice on there when this is supposed to be a grant deed or a trustee's deed upon sale? You don't need to if this is actually a real document. You see? But this were their exhibits. This is as it states, this is a rental agreement. This is this was just some other documents. I forgot what that was. Kind of it was another thing that was on top that actually was showing that it was in compliance with so on and so forth. Why they put that up there, use that, I don't know. And this is considered to be like a landlord tenant notice of possession. You got pay or quit type stuff that they do. This is what this is. This is actually 14 pages, but I just want you to see what these people, how these people are presenting these documents into the court. So hopefully that made sense. Hopefully that made sense. But this is what they're doing. This right here is perjury. It's not just perjury. It's not just perjury. It's fraud upon a court. It's willful intent. It's constructive. And it violates all the ethics. Right? At no point in time that clerk was supposed to accept that. Being the case that, number one, the evidence that was presented was faulty. They never presented the notice of trustee sale because they never mentioned the notice of trustee sale in here. They never mentioned the notice of trustee sale, the corporate assignment of deed of trust, the substitution of trustee. If those things would have been, they don't put those into evidence because they know those things can be turned upside down. So what they do is they put in the trustee's deed upon sale, and they didn't even put it. Oh, my Bluetooth just went out. Notice the trustee sale and none of these other documents because they know, as I said, they could be turned up on upside down. They don't put the notice of default in there because if this is a part of the non-judicial foreclosure process, if this has changed from if this process is a part of the unlawful detainer process, why haven't you presented all of the evidence that led up to this point? The notice of default would have shown that nothing was attached to real property, so it wasn't a sale. The second page, the notice of potential bidders, would have been shown and known that they was only buying a lien. The corporate assignment would have shown that it was actually J.P. Morgan Chase was not the original party in the transaction, and that it wasn't even a mortgage. We ain't gonna talk it. It's more to this picture. They would have known all those different things, but this is what's going on in California, and it's going on in other places as well. But California, they just do it at a rate that's ridiculous. So we put those things together, then you can understand the process of how these unlawful detainers and these non-judicial foreclosures work, how they are complete fraud because there's no right of redemption. You get nothing for it. You're going from an owner of land to a tenant. In a matter of minutes. So we're gonna end it right there. Man, I've been trying to keep this thing down to 90 minutes. I'm gonna get there with it, but once I figure out how to utilize this computer and with this connection, then we'll be able to work that out. Anybody, what I'm trying to do is figure out how to connect the chat to the Zoom. I see that I see that I see that bro Sanchez, brother Sanchez, he uses Zoom and he knows how to put his chat up there and be able to do that. But like I said, if anybody, if you guys want to come up, y'all cool. If y'all want to come up and chop it up, got some questions, challenge some of the information, that's cool. If not, I'm gonna play some music, get up out of here. How long we been live? Boom. 2 hours? Cool. All right. once I edit it and chop it up, I can get it down less than 2 hours. So I'm not doing bad. Let's play some music. Yeah,
Just because they didn't know. They didn't know anybody who knew either. So
right, exactly.
and family be scheming family. So yeah, I didn't like this. This would have been would have came in handy a couple years ago, for me at least specifically.
Yeah, but do you know that, you got 4 years. You can get it back.
4 year, uh, it been longer than 4 years for me,
Yeah, well,
for my people.
even, even
But no,
then,
but yeah, I'm about to say I could like use this to help other people though, like it. So yeah. But what was you about to say?
I would say even then, there's no statute of limitation on fraud.
Oh,
You,
you're
you
right.
see what I'm saying?
You're
There's no
right.
statute of limitation on fraud.
Mm.
Yeah, there's some other stuff that been working because if you bring back that case, right? So, like in the beginning, you saw the case after that daily case.
Yeah.
With that case being in place since 1968, and all the other things that I showed presenting that in front of a court could open it up.
Yeah. Yeah,
So,
definitely.
uh,
Mm. Oh
I'm
yeah,
just
so
saying. I'm just saying.
no, yeah, you're right. 'Cause I was just talking about talking to my mom about my grandpa and my grandma's houses and property.
Uh-huh.
Because she didn't know how to handle it at the time. So
Yeah.
and I was in high school, so I definitely didn't know what was going on for real. For real. I wasn't even thinking about this at the time. So, but
Yeah.
yeah, so I've
Now,
been. Go ahead, my
go ahead.
fault.
Go ahead. Go ahead. No, go
No, I
ahead.
was just about to say. So, yeah. So when I go back and talk to my mom about certain shit that I wasn't privy to as a kid, I'm like, damn, I wish I knew everything I know now back then, type shit. But like you said, it ain't too late.
No. Yeah, I'm working on a couple things right now. That's why I've really just been like just chilling, really, just focus on one thing right now, and that's just uh putting this together. I figure it's the time right now. That's why I said, fuck it, let me go live and let's put this out here. It ain't gonna be all the extras. It ain't gonna be the smoke show. It's gonna be a little different. That's why I
Yeah.
want to get this information out and then put it together. But hopefully eventually somebody will see it. I'm really putting this out there to see if any type of lawyer got some nuts or a little spine that could come out and say, "Hey, I see what you're talking about. Let's get it."
Man, it is some lawyers. I think it is some lawyers that be on that. Okay. Just about
Mm.
networking,
I
finding the
mean,
right ones for real.
yeah, I've been searching high and low, brother.
Yeah,
Believe me. Yeah.
yeah, because yeah, most of them they all about the bag. So yeah, you're
Well,
right.
not
And my
not
fault. Go ahead.
even not even that though. It's like these people they scared to lose their license. They don't want to go up against these big banks like that. They lose their license. They
Mm,
get that shit snatched. I'm telling you, that dude
yeah.
Daly was an attorney. The dude Daly in that case I showed, that dude was an attorney. He got his license snatched. And
Mm,
that judge uh came up missing.
mm.
Yeah. So
Oh
you can
yeah,
actually
yeah, it is serious. Okay? Yeah, it is that serious.
it's, believe me when I tell you when it's that serious. It is that serious.
Mm. Oh,
So that's it's I think at this point in time is a good time I mean, I've been doing this for a while now, so you know, I'm not, I know how to say something without saying it.
Yeah.
So that's why you redact some of those things and just show what's going on. I mean, at the end of the day, these people are on some straight up bogus stuff.
Yeah, facts. I was looking at the the United States trustee program.
The United States Trustee Program. That's
Yeah,
that's
yep.
under that's under the United States Attorney's Office, right?
Nah, the I think it's the justice. Hold on, I'm about to double check to see. But they deal with the man. Yeah, I think you should look at it for sure. But they deal with there is basically a lot of different private trustees, trustee firms, basically like the one you just was looking into. A month ago, I seen that the Rothschild, they got a trustee firm, and they own a lot of trusts, and they was just in a lawsuit, and they filed for bankruptcy. But we know bankruptcy is just a tool they use to get out of paying debt type shit.
Right.
But I forgot, I really ain't had a chance to go back and look at it for real, because I'm really still learning about it. So I definitely wanted to talk to you about that. I'm talking about, bring it up so I could be more specific.
What's going on, Root Word?
Root in here.
Yep.
So salute, man. Hope all y'all doing all right, man.
What up?
Good deal.
Yep. How'd that hit, Root?
Nah, tell me what I need to know though. But I take it somewhere else, but it still showed me what I needed to know. It showed the if you writing facts, I put it like that. If you writing facts in the lien, oh shit, why I get sleepy so fast, or Liz Pendens. I'll be on some squatter shit, but not no broke man squatter shit. On some adverse. But if these banks did some fraudulent shit and they put a foreclosure on the house, right there, that house turns into a REO or a bank-owned home. So it's just illegal what Aton showed. Like, look, man, you ain't even had a right to.
They all in on it, so they all,
I mean, just a lot of it's a.
It is.
I know, I know I'm about
fraud.
to. I don't consider myself ever getting $1 million unless I'm doing this shit. This shit right here, I feel I'm still getting $1 million.
I heard that.
Yeah, it's the U.S. trustee program under the U.S. Department of Justice.
Right. Yeah, it's under DOJ. Yeah, that's the U.S. attorneys. A lot of people don't know that the U.S. attorneys is different from the attorney generals.
Right.
You know what I'm saying? The U.S. attorneys are a part of the trustees process. Yeah.
Right. That's like with the bankruptcy and all that is run through them.
Yeah, exactly.
So
and they're supposed to represent us too. Like
exactly.
It's under Title 25, 175. Hold on, let me share.
Right.
Go ahead.
They're not doing their job as trustees, which is a felony.
Exactly.
No cap.
Let me show you.
And we supposed to receive.
And the president.
Right. That is definitely a felony. They supposed to do everything and everything possible for the benefit of the beneficiaries. Any way they can help at all. And they definitely not holding up to that agreement.
Y'all see that?
Yep, in all states and territories where there are reservations and a lot of Indians, the United States Attorney shall represent them in all suits and law and in equity. And in equity.
So this is what deals with us, allotted Indians. See, because we're not on reservations unless you consider the projects to be reservations, or our communities to be reservations where we're at.
That's
And
a good point.
we are considered to be allotted Indians, because when we moved off our areas, we was every land that we was allotted land, right? They call it
Right.
allotted land, you know. And after that, even though we moved to the West Coast, California or wherever else, even when you buy a piece of property or you buy some land, like I showed, that's still considered to be allotted land. A lot of people don't know you can actually register your deeds with the Department of the Interior, with the Bureau of Indian Affairs. You don't
I
have to
was
be
just
you don't
I
have
was
to be
just looking at
federally
that. My
you don't have to
fault.
be federally recognized to do that.
Mm.
Right.
I had that pulled up to the Department of Interior Indian Affairs. I was looking at their branch of land titles and records.
Mm-hmm. Yeah. Yeah, you can actually do all that. We could do just like we do business with the Department of the Treasury, you know, and doing EINs, setting up corporations. We could do the same thing with the Interior.
All right. I think one key thing we got to do is figure out after the Civil War with the lands, what trustee firms was taking management over our lands and all that type of stuff. If that makes
Right.
It
sense.
was some of Squatchelate and Crockers, bro. Because that's what you call the Freedmen's Bureau is the abandonment, is
Nah,
the
but look, Root, they had
I'm gonna
at the
let me
same
land
time.
my plane real quick.
My fault. Go ahead. My fault.
All I'm saying is you went somewhere and I don't even think you know where you went. That's the key to our problem is the Civil War. Right after the Civil War, it's called the Freedmen's Bureau, and that's dealing with
Hey, right,
abandoned lands.
right.
So if we could really understand that, the only way we're gonna get our land back is through squatting. I digress. My fault.
So it's the real name is the Bureau of Prisoners, Refugees, and Abandoned Lands. So, and at the same time, they had these trustee firms going all over the country, really taking basically trusteeship over our land literally at the same time at the end of the Civil War. With the and the Jesuits was helping all them motherfuckers was working together.
Damn, I forgot to record this damn video. Shit.
Mm.
All right. Now, like Zoom, you can record it and keep it as an archive. It's all good.
Oh yeah. Oh damn.
Well, but see, under all these circumstances, that's why I say, you know what I mean, it's a more simpler game than we're making it out to be.
Right.
You know, one of the ways is claiming a lot of these abandoned lands, like Root is saying, you know what I'm saying, and be able to utilize that the squatting word where you can put it in actual law where it is lawful. They have they have all these lands and properties and stuff that they just got abandoned and vacant. And I mean, out here, they've been letting these immigrants come over here and just get A1 credit, move right in.
Mm. Okay, so to your point, when you had mentioned the persons in the possession thing, we know the corporations are persons. So would the jurisdiction give them possession? If that makes sense.
No,
What's 9/10 of the law?
yeah, possession.
Say that one more time.
9/10 of the law is possession.
Yeah.
I digress.
I mean, yeah, it is.
I'm saying so.
And that's the mean interest when it comes to, I don't know about the trust thing you're talking about, but when it comes to claiming something, man, possession is a mean interest. I ain't saying it's the
Yeah, it is.
also say so, also most high, but it's it's an angel.
Yeah,
Regret.
that's the first shit that gives you the first right to claim whoever is possessing the shit.
That is not always true, but you're right. You're right.
But my point was that so if the land is in the jurisdiction of these corporations of the government, do they have the right to claim? Do they have the possession at all times
Nobody
type
can
shit?
claim land. Land, you have to buy it every year or keep renting it out every year. I don't know the right words, but every year you pay taxes on it unless you do something with it.
No, but I'm saying, do they have the possession though? Like, would that be called? Would they be able to say that they have possession since it's in their jurisdiction? Would they be able to say that?
Ask that question one more time.
With the government corporation, which is considered a person, be able to claim possession of anything under their jurisdiction? Would they be able to make that claim?
No, because corporations can't own real property. They can't own real property in that sense. Like really
Yeah.
not let me not say corporations, but banks can't
Okay.
own corporations. They can't own businesses. So they have no right of claim. Remember.
All right. Right. And we're dealing with the bank. We're talking about the bank.
Yeah,
The
the bank.
banks. Okay.
Corporations can come in and purchase them. You know what I'm
Mm-hmm.
saying? But these investor LLCs, you know, they've been trying to get a stop on the monopoly on that right now. But like I said, in these REOs, like Rue was saying, these REO, these these bank owned properties are coming through this right here, this whole process that I showed you, and that's
Mm-hmm.
unlawful. So these bank owned properties are considered to be abandoned.
Okay. Now I see what.
Right,
Now I see. Now I see what you were
right,
saying.
right,
Yeah.
Root. When we leave, we're actually abandoning it.
Facts. Facts.
Mm-hmm.
We just don't know it. This is what we talk about. It's a 1099A, right? Let me show you a 1099A. And they give you this. If you know anybody, ask them if they've received a 1099A or 1099C after the foreclosure.
Okay.
They'll tell you that it's actually been abandoned.
Mm. So in the case of death, that's abandonment too, right? Would that be considered?
Uh,
I
no,
don't know. They go through probate then.
yeah, I go through probate. But see, this is what it is: 1099, acquisition or abandonment of a secure property. And this is the form. So what they do is they actually give you this. They actually uh they actually send this to you. They don't send you the red copy. They send you the black copy for the borrower. So what they do is this box is being checked. If checked, the borrower was personally reliable for repayment of the debt. They check that. That means it's an abandonment. If they don't check it, it was an acquisition in regards to the borrower. So they have this balance principal outstanding description of the property, and there you go. This is what they do. So in the documents, they actually show you that you're actually abandoned. They're stating that the land was abandoned or the property, something was abandoned, and then from there, they file these other uh they file these other documents with that.
Liz
So
Pendens.
right. Liz pendants, and then that's why this is how they manipulate the courts in regards to a tenant, landlord tenant agreement from there. But these are the documents that they give, and they say that you abandoned. See, but as you
And
saw
see
that,
something you showed in 29 code point 35, section B, part 4, whatever that shit was dope as hell though. But it plainly says, that's why I said stick to the banks. I don't know about all. You say all. I say the majority. Most lenders sell that mortgage to the secondary lender. But what don't nobody know, the majority of them loans, they separate the mortgage and the original note. And they can't produce the original note because the original note is where that security thing you're talking about. And it's on the stock market and they already got their motherfucking money. So now it's double dipping time when the second lender forecloses on you. But you just showed the papers where it's illegal for them to even do anything because they don't have them two papers. That's why I said, wow, you're showing me the real law. But I digress, man.
Yeah. This is something that everybody should do. I said it on the first one. If you had a mortgage, I don't care. If you had a mortgage, your parents or anybody you know, tell them, ask them if they got these three things: grand deed, the original grand deed from when they closed and they bought the house from the previous owner. Number two, their preliminary title report, Schedule A and Schedule B. Number three, the actual deed of trust, the documents they signed or the documents they took with them after they supposedly had fulfilled the transaction, and then compare that to what you see that's been recorded in the county and see if that matches.
Okay.
So you're going to see all kind of fraud in there. You're going to see that the things don't match because the paperwork that you take with you once you're supposed to have closed and everything is not the complete is not the completed documents that is actually being filed. This is why I say it's a real estate investment transaction. They are doing what you call a double close. It's a double close. Double close in real estate. Ain't nothing more important than real estate.
I'm saying by next year, I got the case law. That's YouTube easy. It'll show you all that stuff on YouTube for bankruptcy and foreclosure. Then now you just showed me where the codes is at in California, so you could just follow California to every state.
Right.
I'll have confidence in myself now by like next year, I'll be walking in some REO homes, like kicking in the door, waving the 4-4, hostile as hell, like locking the door, putting the orange fence around that motherfucker, and writing these motherfucking banks a letter like, look, nigga, I declare war on your bitch ass.
Hey, if you do that, I'm doing this. I'm gonna use your blueprint, and we can take over the city. Fuck it. You better do it right, cause it's a lot of abandoned houses out this motherfucker.
I didn't see. I'm doing on some old. I just think I got a loophole, bro, and it ain't just my loophole, but it's a loophole, and it's there. Like, look, man, just check the bank, bro. I'm not going after nobody, no abandoned cribs. If it's a REO, if it's a bank that's going through foreclosure, pre-foreclosure, I can show people that I can look up the mortgage and everything. If that motherfucker sold or if it got MERS on it, nigga, that's my house forever. At least for 8 months. At least I'm gonna get some rent up out that bitch. I digress, man.
Yeah. So this is what the banks is doing. When you leave, they actually sell it. They actually do. Well, let me put it this way: they open 2 more escrows. So there's actually 3 escrows running at the time. The escrow between you and the buyer, you and the seller, and then there's an investment escrow. Then there's a creditor debtor escrow as well. Because if anybody's paying on their monthly payments, you got escrow payments that you're paying in there. Escrow is not supposed to be open. Escrow is supposed to be closed. Now, I was told this, that 300,000 that you pay for the house, that 300,000 is still in escrow. And it could be claimed. This is what I heard. I don't know if it's true or not. But based on all the bullshit I didn't see throughout this stuff, hey, it ain't. I wouldn't rule it out. But this is what they do. Once the grant deed comes to you, the escrow is closed. Everybody say we just closed escrow, and then another escrow opens. It's called like it's either is equated to a double close, a loan modification, or another, or basically more of another sale, because the actual bank, as I showed in the declaration, they're nothing but a mortgage servicer. So if it was JP Morgan Chase Bank and they're the beneficiary, they're nothing but the mortgage home loan servicer. They actually use that language in California. They call them home mortgage loan servicers, not lenders. What they do is they create these REMICs and these real estate investment trusts.
Mm. Oh,
Right? That's what they do.
so this double closing is basically wholesaling type shit.
Yeah. It's like they're getting it at a price and then they're selling it over to an investment company. That's why
Right.
usually at the end of the day, that initial bank is going to be gone. And when you're being sued and evicted, or they do all these things against you, that's when you're going to see the investment company. I have
Mm.
I have done multiple, or have been a part of multiple mortgage and security audits. You'll be surprised at what you see. This ain't got shit to do with a house.
So, but with the contract law, do all parties have to be aware that is a double closing going on?
Yeah, everybody, you have to be aware. Full disclosure is everything.
Right.
Disclosures are not given.
Right. Yeah, exactly. That's what yeah, that's what it sounds like. This happening behind closed door. So it's like you said, it's fraud.
Exactly.
Mm.
So disclosures have to be given.
Mm.
Like, let me give you an example. That's why I said, as soon as you walk in the door of a bank and you open your mouth about a loan, you've already are contributing to what is going to be a fraudulent transaction, which is going to be predatorial to you. Why? Let me show you this. Because we ain't even supposed to be giving out that information. Once you give over your social security number, as you're participating in it, because it is right here. Discloses, uses, or compels the disclosure of the social security number of any person in violation of the laws of the United States. Anybody that discloses, uses, or compels the disclosure of the social security number of any person in violation of the laws of the United States.
Mm.
Requires to commit, right? That's 5 years. You're going to jail for 5 years. So they're not even supposed to be asking you for that. Let me show you something.
Wait, even employers?
Even employers.
Mm. So we all just sitting on here on a bunch of law. I mean, yeah, cases, basically.
Remember, I said applicant, right? This
Yeah.
applicant, this is very important. Everything that you fill out is an application. You fill out an application for a job. You fill out an
Right.
application to open up an account. Fill out an application to get a credit card. An application to get a loan. Application for a mortgage. Application for a car. Application to get your lights turned on. Everything. These are letters of credit. An applicant means a person at whose request or for whose account a letter of credit is issued.
Hmm.
So
Who's an
if
account?
if that's the applicant, then the application.
Right.
So once I come in and they say fill out this application, that application is the letter of credit. I just need you to stretch your imagination. You know what I'm saying? Just stretch
Yeah.
your. You're gonna have to stretch your imagination on this channel. I'm being real direct, and I'm actually showing that this is what it's saying. These words that we didn't understand or we just thought was just a simple process actually has a lot more to it.
Mm.
That application is a letter of credit. It's money in the sense of how the structure is now. As I showed about the HJR 192, you know what I'm saying? That the United States is the guarantor for all debts, all loans, all extensions of credit. The United States is the guarantor, not us. They make us a personal guarantee, but they don't. What they're not telling us is that personal guarantee, and if they are using that Social Security account number, it's all linked to the United States.
All right.
And it's not yours. It's for your use in certain aspects.
Mm-hmm. It's part of the straw man, right?
It's called a social. It's called a social security. It's just
Not,
going on a journey, my brother. It's called a Social Security card, right?
yeah. I'm saying it's attached to the straw man, right?
Yeah, it's an account number that's attached in relation to the Title 15, 1602. I'm showing you something. This is
It's
how
the
it moves, right? The definitions.
the Tin Man. Okay, let me see.
Definitions. Right? So this is 1602. This tell you what credit is. So it tells you what a person is. The term credit means the right granted by a creditor to a debtor to prefer payment. Who is a creditor? The term creditor refers only to a person who both regularly extends, whether in connection with loans, sales of property, or services. So if it's a person is a natural person. Who's the natural person? Hmm?
That's a question, you or was it
That's a,
rhetorical?
that's a question.
Who's the natural person? I am. We are.
Exactly. So if you're the so if the creditor refers only to a person, so person means a natural person or an organization, right? Or it could be an organization,
Right.
but they interchange. Says right here,
Exactly.
organization means a corporation, government, or governmental subdivision or agency, trust, estate, partnership, cooperative, or association. Right. So now if you talk about the straw man, and you talk about that legalese name, it could be considered a
Mm-hmm.
trust or an estate, right? Isn't that name
Exactly.
is it part of an estate?
Exactly. Yep.
Right. So who's the creditor?
Right. 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 The social. At the end of the day.
Right.
Yeah.
So that's
Yep.
what I'm saying. So let's go down here to credit card. What is a credit card? The term credit card means any card, plate, coupon book, or other credit device
Mm-hmm.
existing for the purpose of obtaining money, property, labor, or services on credit. So, so is our license plate a credit card?
They give you a ticket. They use it to give you a ticket.
I mean, it said a
Yep.
credit card is a plate.
Right.
That's what I'm saying. Think outside the box. Okay, so if it says means any card, is the Social Security is that a card? Is the so it's considered a Social Security card, correct?
Right.
So would that be considered a credit card?
Yeah. Yep.
It says any card, right?
Yep.
That's what I'm saying. It's a simple it's a simple game. The game can be really simple if you can apply it. You know, it puts the bank and it puts some of these other people in a pickle because either they're gonna go along with it and say, "Oh, okay, all right, you know what's happening," because you know how to communicate, or they can act, you know, intimidate. They could try to be intimidating and threatening and say this and say, "Oh, you know, you're talking about this and talking about that." No, how about this? Let me give you this code, Title 15 USC 1602. What does that say? You asking me my social security number? Okay, how about Title 42 USC 408, number 8, 9, and 10? How about that? Oh, you want to do this? How about this? You say you're loaning me money? How about this? I can do that. I can do that. Literally, I can do that. I can stop them right at the gate. Now, what if they deny me? I didn't give them pretty much the laws, statutes, and regulations that they're supposed to follow. What if they still refuse to service me? Right? Because you remember, I showed you got a mortgage servicer. They're home mortgage loan servicers. They're loan servicers. They're credit servicers. They're not lending or
Right.
extending. Right? So if they deny to service me in the issue of me trying to acquire something for my own family and personal use. Let me say it again.
Ain't that discrimination? My
I'm
fault.
not
Go ahead.
trying the terminology is I'm acquiring something for my own family personal use, not for profit. And they deny me. What is that considered to be? Discrimination,
Right.
prejudice,
Right.
right? You're not refusing service because I'm being belligerent or I'm coming in, you know, feeling like all out to be damned and, you know,
Yeah.
like I'm homeless or something or anything of that nature. I'm coming in doing business properly.
Right. And I'm qualified to do it.
You see? So they say, okay, well, hey, it
Yeah,
gives you
yeah.
ground for suit. Gives you ground for
Hey,
suit,
right.
right?
Exactly. Yep. Because as long as you qualify, they can't turn you away. As long as you
Right.
qualify.
What are they gonna say? Well, he came in and said 15 USC 1602, and this social security card is a credit card by its definition. And he gave me my social security number because Title 42 USC 408. Judge is gonna say, well, let me see these codes real quick. Okay. What's wrong with that? But wait a minute, how we normally do things, just like the guy said in the 1968 case, we do these just by a matter of this is how we do it on normal course of business. Whether it's right or wrong, we don't care. This is how we do things.
All right.
But this is how they're doing it. And they will say that. They was like, this is not the normal way we do things here.
But you can do it.
We do it this way. And if you don't want to do it this way, then we can't service you. Okay, no problem. You are denying me my constitutional protected rights, the right to life, liberty, and pursuit of happiness. And happiness is me getting into this $100,000 Jaguar
All right.
and getting this $1 million house with my credit card. You
You
see what
might
I'm
as
saying?
well service me now before we deal with the court. That's you don't want that. That's exactly what they don't want for real.
Right,
So
right. Remember,
like you said, it's all about the communication and yeah,
there's no money.
right.
Right. I
And
showed you the coinage jack, right? Coinage jack said what's money? What's a dollar? Right? A dollar is a fixed weight of gold or a fixed weight of silver. It's not an FRN.
right.
You see how I'm laying it out?
Nah, yeah, I'll be with you. That's what I was saying the other day. I'll be with you on life, but this is what I be wanting, like this type of breakdown for real.
Yeah, I mean,
Because I studied the history of the currency, the U.S. currency, and like all that shit is important. It all connects. It all connects.
yeah.
I want dang. You feel like looking at this video? I tried to play it the other day. Um, when you was talking about the corporation, it's a video about the straw man.
Which one is it?
Hold on, I'm gonna post it in the chat that you can look at it before if you want. I gotta go get it. It's on my Twitter. But man, I know you're gonna like the video for sure because it's basically it's more evidence for everything you're saying now.
Right.
But it's definitely a good conversation starter too, because it's a lot of information in the video to break down to get a better understanding. That'll help tie in everything together even more with the stocks, with the Social Security, birth certificate, how it's all being traded. Man, it's all, like you said, it's all connected. Hold on, I gotta go find it out. And I tried to add your TikTok. It said it wouldn't account no more. All right.
Yeah, and then after this, we'll go ahead and shut it down because I know damn, it's already 3:20. Yep.
Can you see it?
Let me see.
I be forget you in Cali. I'm on the East Coast, so it's 6 over here.
Yeah. Hold on, let me share it real quick.
Yeah, I got a lot more videos too.
Paying fines,
that we can go
and attending court are all optional, and that you are conned into agreeing with them.
All right, fair use, fair use. Fair use.
What would you think? It has been said that you need to know that you're in a cage before you can escape from that cage. Let's look into how you're being tricked and how your power is being hidden from you.
Ah, the government. It loves you and wants to keep you safe and well. It even wants to make paying taxes, fines, and court costs easier for you. How? Well, you'll need to meet your straw man.
Your straw man is a fictitious legal entity created at your birth through your birth certificate and the registration of that birth.
Here's a definition of straw man. A front, a third party who is put up in name only to take part in a transaction. Nominal party to a transaction. Black's Law Dictionary 6th edition. The term is also used in commercial and property contexts when a transfer is made to a party. The straw man simply for the purpose of retransferring to the transferor in order to accomplish some purpose not otherwise permitted. Barron's 3rd edition. The straw man is an artificial person. The straw man was created by law shortly after you were born via the registration of the application for your birth certificate. The name for the straw man is your name in all capital letters. You will notice that the inscription on the birth certificate in your name is in all capital letters. The English language has precise rules of grammar that make no provision for writing proper nouns in all capital letters. So your name spelled with all capital letters is a fictitious name.
Whenever a human being is born, there's two entities. One is the real entity, which is the human being, the flesh and blood. and the other is a legal fiction, a fictional entity that is nothing more than a piece of paper, the birth certificate. Again, we're duped into believing that these are one in the same, and so we're tricked into representing the legal fiction, the straw man, that birth certificate. So when people get fines and things like that, it's actually consulting the legal fiction, the non-existent entity, the corporate entity that is owned by corporations.
You have any interactions with the bureaucracy, okay? They're not interacting with you. They're actually interacting with your legal fiction, because they can't deal with a flesh and blood human. Yeah, they have to deal with another corporation.
When you start to break down the words that we use, and you start to look at the roots of all these words, and you actually look at where these words, what these words actually really mean, you start to get an idea of what's going on. The word corporation is very, very specific, because it's corporation, it's dead speak. So a corporation is something that's dead. It's an entity that exists only in a legal framework. It doesn't exist in any other framework at all. It only becomes an entity through legal mechanisms and legal means.
In essence, when you were born and far too young to understand, a company with your name was created through your birth certificate. When your parents registered your birth, they actually created a company and handed ownership of that company and you over to the state. It is important to remember that your parents were tricked and had no idea this was happening.
What you thinking? Yeah, I know it's a 10-minute video.
Yeah. We'll stop it right there. No, yeah, there you go. Oh yeah, I'm on it. Yeah, you see, that's a USFL thing. I heard that voice. You familiar with USF? You familiar with USFL?
Nah.
Oh yeah, yeah. You should sub up to his channel. Yeah, I think it go by higher frequency radio.
Oh, he got a page. It's a page.
Yeah, he got a YouTube page.
USFF. Hold on, let me see.
Yeah, I'll put it in the back chat.
All right.
Let's see here.
And I just came across that video shit not too long ago, for real. Literally. I said I just came across that video recently.
Yeah, he a good brother.
So yeah, it ain't like this is only information for so black people, quote unquote. Like this is shit. Everybody dealing with these problems, and they all pissed at it too. So
yeah, I mean,
so I know that the indigenous thing is an indigenous problem, but it's a lot of problems out this motherfucker got to be tackled. And I think people tend to forget that type of shit and focus on the so identity thing too much. Like they don't people it takes away from them studying other shit and researching other shit to help support their claim.
Yeah. that's why you know, I like to provide, you know, my services. You know what I mean, because we got that. I mean, it seemed like all that stuff is of conversation, but how does it relate to us? You know what I mean? That's the key.
Right.
I put
Exactly.
the link in the chat, in the back chat. So
Okay,
if you understand, if you understand how this is taking place, and then you can put it to some real American real American business, you know what I'm saying? For us
Right.
as melanated people, then you can really, tie it together and be able
Exactly.
to reclaim it back tomorrow.
Right.
Because it's being
Right.
seen as abandoned lands. But if anybody of the common sense, whether it be me or you, we knew all this stuff, we say, okay, well, I do own the land, and you sitting there trying to take me off, and what if I try to defend my land from me being removed off my land? And I take the actual measures that needs to be taken. You know what I mean?
Right.
Who's in the right and who's in the wrong? This is where it get. Well, you was supposed to have no. Here's the law. This is why I did what I did. I protected my land. I don't care who he
Right.
was, sheriff, police. I don't care. They're getting taken down because this is my land. They're trying
Right.
to physically remove me off my land, like some KKK stuff.
And we got the constitutional duty to enforce that law.
That's right. That's right. So, I mean, I'm just hypothetically speaking, but if you want to keep it to the letter of the law, hey, good for the goose. So, but but yeah, but yeah, brother, I'm gonna go ahead and shut it down. It's 3:30. I'm gonna go ahead because I want to get prepared for later on, and got some other things I need to take care of. So I
All right.
appreciate you coming up here, brother. Come on back. We're gonna get to it. We got more to break down on some of this stuff. All right.
Yeah, for sure.
And
Appreciate
if
it.
you got any links, anything you want to discuss or you want to tackle, go ahead, hit me up.
All right, I got you.
All right, bro. All right. Well, that right there will uh end it for now. Uh Shout out to Root Word, shout out to Master herself coming through, representing everybody that was in the chat. Come through. Anybody else after the fact, do that. Appreciate you, Kala Calhoun, um, for the good shout out. A note, 424, smoke signal. Nah, Sean P. Diddy. My bad, I didn't drop the link for you. Come on back. Hopefully everybody subscribe. Watch it over again, Copper Draco. And another one. Everybody else that was listening that always win. Everybody else that was listening that wasn't able to comment. Hey, you're looking out. We'll be back again.